In the spirit of reconciliation, Law Squared acknowledges the traditional custodians of country throughout Australia and their connections to land, sea and community. We pay our respect to their elders past and present and extend that respect to all Aboriginal and Torres Strait Islander peoples today.
Hello and welcome to Contracts at the Speed of Tech. I'm your host, Annika Childs, commercial lawyer and strategic enablement lead here at Law Squared. It's great to be with you again today as we discuss some of the emerging pressure points in modern IT contracts. IT contracts have, of course, become the backbone of modern business, whether you're procuring software, outsourcing a service, or integrating third-party platforms. The risks embedded in these agreements can have significant commercial and operational consequences. But in many cases, technology is moving faster than the law, and your contracts are on the front line. From SaaS to AI, today's IT agreements carry new risks, sharper compliance demands, and untapped opportunities to capture business value. This is a subject that my colleague, commercial lawyer and team lead at Law Squared, Vladimir Kravchenko, is passionate about and recently wrote a great blog about called Beyond Caps and Indemnities. If you haven't read it, we'll pop a link in the sidebar. When he's not authoring commercial law vlogs or leading our firm's response to the Australian Treasury's review of AI and the Australian consumer law, Vlad is a corporate and commercial lawyer with a deep expertise in drafting, reviewing and negotiating contracts across their full life cycle. Drawing on his background as in-house counsel at one of Australia's largest companies, Vlad delivers clear, practical and commercially attuned advice to clients across financial services, underwriting and beyond. At Law Squared, Vladimir also supports our Law Squared as a Service or LSAS clients, acting as a trusted relationship manager for their ongoing contract and advisory needs. Welcome, Vlad.
Thanks, Annika. Thanks for that glowing introduction. I sound very impressive and like a real geek based on that. I'm delighted to be here in a great company of esteemed colleagues.
Thank you. And also please make welcome Gihan Wijeratne. He's head of legal and company secretary for global leader in payments technology solutions, Ingenico. In this role, Gihan advises executives and boards on strategy, regulation, and complex cross-border transactions. With deep experience across banking, fintech, and technology, Gihan delivers legal excellence with commercial insight to help businesses drive change and capture opportunities. He's also a regular contributor to industry panels and forums. We're lucky to have him, offering practical perspectives on how organizations can grow responsibly in an increasingly digital and regulated global economy. Welcome, and thanks for being here.
Thanks, Annika. Thanks, Vladimir. Good to be here with my fellow IT contract nerds. Looking forward to the discussion.
All right, listeners, hopefully you know the drill by now. We've got just 1 hour for this webcast, so to help us manage time, please drop your comments and questions into our chat moderator, Lisa, in the sidebar to my right. We'll respond later with FAQs and resources after the webcast. So Vlad, in that recent blog I mentioned, you postured that tech is moving faster than the law. Can you unpack what you meant by that, and I guess share some examples where we're seeing this gap in real-world IT agreements?
Yeah, for sure. I'll try my best. It's an age-old thing where new technology is created that society, including legal professionals and legislators, are not well versed with, and so the legal nomenclature or conceptual thinking is often not there to support certain features of a new technology. It's particularly relevant in the digital world. And a good example of that is, the very hot topic of AI. Most AI systems are autonomous and adaptable. So they can change over time and make decisions with little human input. What that means for the law not being always adequate is that sometimes the language we rely on is too clunky or simply doesn't capture this specific nature of the technology. So, for example, with consumer law that all our listeners would be familiar with, there are these principle-based terms. There's the concept of reasonableness, or fitness for purpose. When you start applying it to something that adapts and changes over time, it sort of tests the application of that law. So, an algorithm can kind of take you somewhere where that you didn't think it would at the point of purchase. Another example is the Australian copyright framework. To get protections for under the Act, and the way Section 32 is being interpreted by courts, the requirement for originality, means that the author of a work that's subject to copyright protections needs to be a natural person, a human, basically. So that really raises a question mark as to whether outputs of AI models, as used by all of us these days, get that protection. And so that's what I mean by technology outpacing the law. And on the level of, say, contracts, we all have templates that we rely on that try to articulate very abstract, very nebulous terms. And sometimes the intricacies of a technology are, not well understood, or it takes time for the lawyers drafting those templates to understand exactly what the mechanisms of the technology they're trying to control in a contract are, and properly word the protections needed.
So given, I suppose, that pace, then are those traditional contractual clauses and elements still important for managing risk?
Oh, more than ever.
Yeah, well, I've heard you say before, I guess, the importance of modelling risk and price together from day one, I guess, in relation to kind of those traditional contractual elements. What does that mean in practice then, especially, I guess, for IT agreements?
Yeah, this is actually a conversation Gihan and I were having not too long ago about how, for example, in M&A, there's this way of trying to quantify the risk a certain deal exposes a party to, and then making sure that that's reflected in the commercials. So doing the kind of math and trying to understand how the commercials change as the risk increases or decreases. With the way contracts are often negotiated, is that the commercial team might go off and have a discussion and agree on pricing before the lawyers are involved. Then the liability caps are not aligned with the business's appetite for risk, which in theory should mean an increase in fees under the contract for the party who's accepting more risk. But there's often a misalignment between the two. And so what I meant in that article by that is that the lawyers should be involved early on so that they can influence the actual pricing, the commercial side of a contract based on the risk the business is taking on in that contract.
How can legal and commercial teams, I suppose, work together better to ensure that there's that kind of appropriate kind of flex that we need in IT contracts?
Yeah, perfect. So great example that Vladimir had around the legal unlocking a lot of commercial value. So if you're looking at IT contracting from a vendor perspective, so in Ingenico, we supply a lot of software and solutions as part of our overall product and service stack. Now, when it comes to the risk profiles with customers, we essentially have them in categories, and sometimes our big customers do not want to take on much risk, and Ingenico as the vendor has to take a tremendous amount of risk outside of its general risk appetite, outside of its general contracting principles. So how does legal work with the commercial teams on that? Well, there's an opportunity for legal to really add value with quantifying that risk and going, well, I'll give you a practical example we're working through at the moment. So we generally like a liability cap of 1x fees. Customers like looking at their risk profile around everything we're delivering to them and putting a big, say, 200 mil cap on it. That might be severely outside our risk appetite, but we decide, all right, well, how about we influence a bit of the pricing? How about we influence a bit of the operational risk here where we can actually be risk forward thinkers, capture this risk, and without having to be defenders, we're actually moving the business and holding hands with the commercial teams and driving business and commercial deals. So what that would look like in practice is, well, we've priced at 1x and we haven't really locked in pricing at that stage. We advise the business, we work together with the customer, and the customer essentially wants to have these higher liability caps, which is totally fine. We just need a price for that risk. So we've seen this operate really successfully at Ingenico quite a bit. So what I'd implore legal teams to do is get in early with your commercial teams and don't be the last denominator with the contract, just that last mile. Start the contracting early, advise early, and close that deal.
And obviously there's that long-term benefit of that as well. I suppose let's go to something more concrete, SaaS agreements. So these types of agreements are now a staple in today's tech landscape and an essential part of any in-house lawyer's role. Gihan, what makes SaaS agreements different from conventional IT agreements? How do they require a unique approach in drafting and negotiation as well, I suppose, on top of what you've just said?
Yeah, so if I put them in two buckets, you've got your SaaS vendors, so solutions that we're procuring, and then there'll be SaaS contracts that we're supplying that SaaS, right? So if we look at just IT vendor contracting, right? A typical view I see with a lot of procurement contracts in companies is that, well, if it's below a certain amount, I'm not going to review it. It's below our threshold, or it's not worth the time to review it. But SaaS contracting, the risk profile is very different to an equation with the money, right? So a $1,000 vendor contract with SaaS might actually represent millions of dollars of risk to the company. This is generally because SaaS vendors will be holding some sensitive data. They might be holding not only the company's sensitive data, but we're talking about our employees. I'm talking about our customers' customers potentially. So we get wrapped around in this really increased risk profile that sometimes kind of gets buried underneath the rug and gets forgotten about. So I'd say there's a heightened risk when it comes to SaaS contracting, especially with vendors. Key points are just understand what the risk profile is and advise accordingly, because not all SaaS contracts are created equal.
That important initial step of just finding out what you're actually getting, I suppose, as well. When it comes to SaaS contracts, there are several clauses that need careful attention. For example, like you said, clauses relating to data ownership, obviously, service levels and termination rights. Vlad, which clauses do you think are the most critical for both the service provider and the client? Are there any kind of pitfalls that you kind of often see in these areas?
I'd love to make one more remark on the last question. I thought your response was great, Gihan. Another thing that in my mind that distinguishes SaaS contracts from traditional IT contracts is the ongoing nature and the ability for the service to evolve. That needs to be, from the vendor point of view, that needs to be baked into the contract and accounted for. Iterating your software, changing the SLAs as time goes on. It's an evolving sort of beast, instead of you buy something off the shelf once and Bob's your uncle. So that really creates a few challenges, that evolving nature of SaaS agreements. You have to watch them a lot more attentively. In terms of which clauses are important, I would say that your indemnity and liability clauses are still the most critical ones, as in any contract, and warranties, of course. The clauses that are unique to SaaS agreements that can be a real problem if they're not properly drafted or negotiated. Data harvesting clauses, for example, most SaaS, or not most, but many SaaS businesses out there these days rely on the ability to collect the data of their clients and use it in some way, typically to commercialize it or to build additional service offerings or to improve their model. And the way that's typically phrased in a contract is that, the provider might get access to anonymized data for learning and development or improvement purposes or something like that. The risk that poses to the client is that often those clauses will capture data which might be anonymized, but which might still be commercially sensitive. So, for example, in the banking space, if you're a lender, you might have all sorts of formulas, metrics, and mechanics built into how you evaluate risk. You engage a SaaS provider to help you with risk assessment, and you ask them to develop certain custom fields, for example, in their platform or some other features. The provider would typically view that as something that should belong to them, and will also ask for anonymized data. Yet, the custom configurations you ask to build based on your business's logic and previously developed formulas that could have taken years of refinement and very valuable proprietary information. They would get caught by that language, and they shouldn't. That's a real risk. So that's a common thing I see. There's also this is a clause that Gihan and I have discussed previously in a classic concept that we've discussed previously in our working relationship, the ability to update a software. It's very important for a vendor to be able to do that, but it can be very disruptive for a client. So from a client's perspective, let's say you buy an expensive SaaS solution that is going to drive your business for the next 5 years. You have to train your team on its features. You have to put in place policies, manuals, etc. And you have to configure it to work with your other systems. If the vendor then goes and tweaks something to improve their system, that could have significant repercussions for how you operate and can cost a lot of money. Yet from the vendor's point of view, if they're unable to do it, it creates a real problem because they need to be able to improve their software and keep it profitable and competitive, etc. So that's another one. And then I often see vendors not wanting to take on responsibility for third-party components of their offering, which this day and age are very common. So most SaaS solutions will rely on integrations from third parties, and where they are critical to the service offering, it becomes a problem where no one's responsible for them if the service provider insists that they shouldn't be under the contract. So that can be a real challenge in negotiating them. I'd love your thoughts on that, Gihan, and on any other clauses that you can think of.
Yep, and thanks, Vladimir. Yeah, I agree. The updates, upgrades, and new releases is a tension point. So I'll give you an example. There's a big legal AI company that's pushing out updates twice a week. Now, that can be great, right, from a feature set perspective for a customer. But if it impacts your workflows downstream, that can cause a whole range of headaches. So we've found potentially a good middle ground is where you have updates are just getting pushed which have no impact to the customer. We have new releases that have a bit more of that may have an impact on, new feature set, configurations, integration work with sort of a lead time with our bigger customers. But then you get situations where, well, how do you clarify what is an update that has an impact and what doesn't? So there's this ever-evolving change and tension between the parties on that front. One thing that's also come up recently is if you're delivering SaaS services in the EU is the EU Data Act. So baked in there, so it came into force on the 12th of September this year, and baked into that regulation is a termination for convenience right for customers on 2 months' notice. Now, this is going to cause a whole range of headaches. It is for a lot of SaaS companies, and not only from a risk profile and certainty perspective, but everything downstream. So how do you, have price certainty or revenue certainty that goes into your pipeline, your planning, and just the whole purpose of your company? If you can't plan for your roadmap and pipeline because you've got this 2-month termination for convenience right on all your contracts, it puts you at potential material risk, right? So there are some avenues you can look to explore in terms of early termination provisions around compensation, working with customers to end up sort of baking a bit more certainty. But that's something that's recently come up that I think will be a vexed issue for quite some time unless we get some further clarification from the policymakers and the lawmakers there. And another one I see with SaaS contracting is the sort of evolution of the roadmap. So you might decide for a business, like we're going in one direction, but now we've got this AI plugin. Now that could actually just change. Does that materially change the scope of your product, or you're still doing the same thing? So how to capture that in the updates, upgrades, roadmap piece is something that I think SaaS contracting, you just have to be pretty cautious about.
Another challenge we kind of dealt with recently as well is that kind of regulatory pass-through as well, where suppliers are trying to shift their compliance obligations onto clients as well. I guess that I'd like to know what kind of strategies legal teams and you're using, Gihan, you're employing, I suppose, to when you're negotiating agreements, that you're not kind of bearing unfair or kind of regulatory burdens that really shouldn't apply to you.
Yeah, we've actually taken the opposite approach, Annika. We stand by our product, so much so that we'll actually take on probably more than the baseline risk when it comes to regulatory risks of our customers. So we say, look, customer, we give you this product and stack of services. We stand behind it, and we'll agree to, if there's, you get a regulatory fine for the things that we imposed or done by our products, we'll pay. But we're so sure of our product's robustness that we're happy to take on that risk. When it comes to things like cardholder data, PCI DSS, this is where we have to really be careful around where's the line, how do the indemnities work, and you've got this complex payment ecosystem where having the responsibility matrix on who is responsible for what is really important. So we have sort of two ways to go about it. One, we'll stand behind our product, we'll actually take on more risk, and that gives us a competitive advantage in the market. Two, where there's a complex ecosystem of payment providers, and we're talking about complex arrangements with PCI DSS and that intersection with liabilities and schemes, that's where the allocation of risk is really important to get it in writing.
Vlad, have you had, I suppose, not limited to SaaS agreements, but the same approach to kind of that pass-through concept?
Yeah, I'd love to make a passing comment on how sort of unique, from my experience, the model Gihan just described for a SaaS provider taking on and kind of warranting that it's taking on regulatory risk and warranting to a client that it won't breach applicable regulations. Very rare in my experience. Most SaaS vendors will fight tooth and nail not to have something like that in their agreements. In terms of other regulatory pass-through matters, so a common thing I've seen in recent times, because we deal with lots of energy and infrastructure clients who are sometimes bound by the SOCI Act, Security of Critical Infrastructure Act. Now, that act applies to specific assets and responsible entities who sort of manage or service or own those assets. And so then they only apply to the subcontractors of those assets to the extent, I'm simplifying things here, but to the extent that they provide services in relation to a specific critical asset, not otherwise. And what I've seen vendors do to whom the SOCI applies is, with a really broad brush, they just chuck in a clause saying, you must not do anything that will cause us to not comply with the SOCI, simply to make sure that, they're covered. Yet often there's no need for a clause like that, because the specific services that the SaaS provider is providing does not relate to the critical asset at all. And so that then causes protracted negotiations. Often the service provider will go and obtain legal advice on whether they need to comply with the SOCI and to what extent they can push back. And so my advice to vendors would be to be very methodical and prescriptive with those things, to really understand when they need to pass through terms like that, and to not do it with a broad brush. Otherwise, you're just going to spend a lot of time and energy negotiating terms you don't need to negotiate.
For sure. All right, let's turn to the elephant in the room, AI. You knew we were going to come here. Come on. So obviously it's transforming industries, but as it does, it's also bringing a whole new set of risks. Vlad, can you walk us through the key risks that you're seeing that are now kind of inherent in AI agreements, and what impact it has on the types of clauses we include in agreements as well?
Yeah, I feel like the nomenclature isn't there yet, broadly speaking. The AI agreements are not yet a staple. I'm now starting to see AI clauses, and they're very cautious. And again, often they often come from a place of kind of ignorance and fear of AI, and not wanting to take on more risk. And so often contracts just prohibit the use of AI or require disclosure, but what people then do with that disclosure is unclear. In terms of the challenges that AI presents, is there are a few kind of issues with how generative models work. And when we talk about AI these days, I think it's useful to clarify that what we're talking about in the legal space are generative AI models, the LLMs, the large language models that basically create human-like text and can converse with you. And there are a few challenges there. The first one is the data on which they're trained. If the data isn't of high quality, or doesn't encompass subject matter that you'd want it to encompass, that you'd want to address in the outputs that the AI spits out. So, for example, let's say you need an LLM to talk about market conditions in Asia, and it's been trained on data from Europe mostly. Its outputs won't be very relevant or accurate when you ask questions about Asia. Then there's the issue of the so-called black box effect, where the results produced by the algorithms are not explainable in human terms, simply because the processes involved in arriving at a result are so complex due to huge data sets, but also to the algorithmic tweaking that happens, after the models are trained on the data, because what happens is that they first go through lots and lots of data, and they're then taught how to produce results that are useful to a human, and a lot of bias can occur there. But also the complexity of the process means that if you need to demonstrate that your decision was transparent, for example, under regulation or in court when you're challenged, it can be very difficult to do, because you might not be able to say that, let's say you relied on an AI decision, it can be hard to demonstrate that it was indeed transparent or reasonable. So they're the kinds of challenges I'm seeing.
So I guess maybe for you, Gihan, as AI technology does become increasingly embedded in decision-making processes, and there's that obviously a real concern around its impact on high-risk decisions. What, I suppose, especially in kind of, healthcare and financial services, what kind of human safeguards, I suppose, are you building into contracts to mitigate those risks?
Before we go into the customer-facing AI contracting automated decision, we've got some internal workflows where there's human in the loop, and so I think that's an important safeguard, even to apply for customer-facing or external-facing AI use, where you have a human in the loop and you kind of mitigate that automated decision-making process where you're entirely reliant on an AI LLM output. So when it comes to customer contracting, an interesting discussion with an overseas English bank around AI use. They mandated a clause in this SaaS contract so where the supplier, the UK banks, the customer, they mandated a clause where they wanted a prohibition on the use of AI in the SaaS solution stack.
That's what I was talking about.
They lost it. They were like, well, how can we, this is going to derail our roadmap. These customers are Luddite. Like, how are we going to deal with this in reality? And we came to a conclusion that, well, I think it's fair for a customer wanting to, control a bit of the feature stack. We might be able to segregate it as long as we have the proper governance. But we were down to the 11th hour, and we ended up getting a clause in there saying, well, we'll get your prior written consent before putting in any automated decision-making tool, because AI or machine learning is quite wide. So having something that captures that breadth of scope is just kind of unreasonable. So what we came down to, what was important to the UK bank, it was that automated decision bias piece that put potentially its customer book at risk. And then there's some reputational risk to them, and we were stepping into their shoes when it came to some of its customers' reputation. So this was quite an important thing. So I thought that was quite an interesting story on how AI is viewed. Some customers don't get it, some customers do get it, and there's a whole spectrum in between. And I think what's important is really the governance around this, and everyone will be different, but I think it's important to have an aligned approach internally within your customer base, within your company base, before sort of looking at vendors and looking at customers.
Yeah, Vlad, do you have anything to add to that?
Yeah, I do. One thing that sprung to mind is we keep talking about automated decision making, and where AI is making a lot of headway and really saving businesses millions is in the data verification or ID space. Your AML, CTF compliance, KYC, because these algorithms can scan large swathes of data a lot more effectively and a lot faster than a human can, and give you pretty accurate results. And then, it spits out the likelihood of compliance or non-compliance very accurately. But where you're not confident that the AI has been configured well, or where the supplier of the AI doesn't, unlike Ingenico, warrant that the use of that AI won't lead to regulatory breach. As the user of the AI, you face the risk of systemic recurring breaches if the thing doesn't actually work properly. And so it puts a lot of pressure on that human in the loop to get it right, but also on the directors of a company to get it right, because there could be some risk exposure to them as well.
Yeah, well, my next question was where are the AI outcomes are unpredictable and potentially harmful. How can we future-proof contracts? How can in-house teams kind of future-proof their contracts against those kind of emerging AI regulations, and particularly, I guess, those kind of ethical considerations as well around that? To either of you, it's a big one.
In terms of future-proofing your contracts, it's still, again, we're talking about the tension around technology and the law and contracting not quite keeping at pace with one another. That's why some of these clauses around comply with applicable laws, indemnity for applicable laws, that sort of stuff gets you into a very dangerous territory. And as Vladimir mentioned before, this creates a lot of risk when it comes to, you have to seek legal advice. You've got customer commercial tensions, trying to enforce some sort of potential breach of law or breach of trying to get a pass through for a regulatory action against you as the vendor. So there's a lot of issues here in terms of, again, going back to how do you quarantine this, or how do you sort of mitigate this risk? It's really working with your customers, vendors around, well, this is sort of the line that we see it. And we can revisit this in our governance meetings. We can revisit this in the contract renewal in 1 year's time. We might have some rights around if there's a change in law, change in policy, change in scope, then the parties will, might trigger some sort of not automatic termination, but the ability for the customers to reprice, or the ability of the customers to essentially set off in a process where they agree a variation to address the new change in law or change in scope. So that's something that works successfully for Ingenico on a couple of occasions, not specifically with AI, but specifically in relation to a change of law and policy. So that framework may be useful when it comes to sort of safeguarding the interest of you as an IT vendor or an IT supplier of AI solutions. So something to consider.
I was just going to say, I guess the key to that too is making sure that your lawyers are able to articulate that and put that to the other party when they're negotiating as well, to make sure that, that they're aware of that broader landscape and need to future-proof for the benefit of both parties. Over to you, Vlad. Did you have anything else to add?
Yeah. I'd love to just elaborate on the theme. I don't think there's this silver bullet way of future-proofing your contracts. A good starting point would be for each business to understand how AI, what it is. Many people haven't bothered to actually understand the mechanics of it, at least in some simple terms, that it relies on data sets, that there's some algorithmic fine-tuning, and that there's bias that's possible due to that fine-tuning, and hallucinations, because it gives you the most probable answer rather than the correct answer. So most people are not aware of those shortcomings, and businesses need to educate themselves as to what it is. B, think about how they are using AI and how that might impact them from a legal point of view. And where I think I see this heading is like with privacy. It used to be, something people would just brush off as low risk or irrelevant. And increasingly over the last 10 years, as people started getting fined and the notifiable data breaches have cost businesses millions of dollars, responsible businesses started carrying out privacy impact assessments whenever they employ a new tool. And I think what will happen is that people will start designing algorithmic impact assessments where before deploying a new AI tool, they'll have to answer a few questions relevant to their business and the legal risks or regulatory exposure that their business faces to see how that tool matches up against those risks and whether, it complies with the framework that the compliance team, for example, has set up. So, and I would recommend doing something like that. And then the contracts will have to reflect, an assessment like that. So, and it would be, you draft the specific clauses on a case by case basis. So to give a very kind of simple example, let's say you're a marketing agency and you're using AI to create heaps of content that it just pushes out there. The major risk for you, regulatory risk, would be that you'll engage in misleading and deceptive conduct unwittingly, because the AI could be, creating content that's not a mere puff and is, exaggerates the qualities of your goods or services to a point where it misleads the reasonable, consumer. And so you'd need to make sure that there are safeguards in place in the contract or in the way that AI is configured, that it does not create misleading, deceptive conduct that you're going to use en masse. So, something like that. But obviously for big businesses, for regulated businesses, particularly in the banking and finance industry, for example, that would be a lot more nuanced, and you'd have to, make sure that any automated decision making, for example, in the AML CTF space, is properly considered.
I guess moving on to our next kind of topic, I think it's sad but true that many legal teams are often seen as the risk police or the handbrake to happiness in-house. But we're seeing a real shift happening where legal can be seen more as an enabler and of growth and innovation. And we've kind of touched on that a little bit already about that partnership between legal and the business. But Gihan, in your experience, how can legal teams position themselves to be viewed as partners in kind of driving that business growth and competitive advantage, particularly when it comes to tech deals?
Yeah, good question, Annika. So there's probably two key things for me, and I know we've talked about it, I think, in this space quite a bit, but it's really trying to, one thing is leveraging AI tools to get rid of the mundane work and some of the low value work, so you can really focus on the strategic, the shifting the needle, the high value work. So how does that work in practice? So you would allow a lot of the contract first pass reviews to go through your AI system as a first pass. Have your contract guidelines set up and have a red line against it, or let it create an issues list so you know the issues with your customer, or your vendor, and you can really get to the crux of it, identify your risk pretty clearly, and really talk to that risk piece and get in deep with the strategic impact of your role. So that's one thing. The other thing I found is it's quite, the AI tools you can leverage around risk identification and quantifying it. So one thing we do at Ingenico is this thing called the legal value proposition. So this goes back to your earlier point around how does legal and work with the commercial teams to drive outcomes. So a lot of value is in these contracts, right? It's not just a mechanism to bill. It's not only just a risk allocation framework. It's really sets the standard for the commercial relationship overall. And so there are these, like, I view them as strategic assets that you can actually then leverage and really extract the best value out of. Talk to your internal business teams and show, hey, there's a lot of value here. Quantify the risk, price for it, have those discussions, and then and drive it with your vendor or your customer. So AI tools can be really useful in doing that and really show a lot of value that the legal team has. So back to, what's the role of your in-house lawyer? It is to protect the assets of your business, but it's also to get the best value out of those assets for the business. So I think that second point is lost a lot of the time, and it's really something that we as lawyers in the IT contracting space really have an opportunity to really shine here.
Vlad, do you have any insight on that, like in just around, I guess, some kind of concrete examples of how legal can ensure that that value is captured in the contract itself, so that I guess you're not left with kind of vague benefits, but more kind of measurable, actionable results, so that you are kind of extracting that full value?
Yeah, I actually beg to differ. I always thought that the role of an in-house lawyer was to wear a risk police hat with, a shiny emblem and to say no to the wonderful ideas of the C-suite. I completely agree with what Gihan said. To my mind, there are two sort of main buckets where a lawyer can unlock value for a business. It's contracts, but also proactive regulatory response. So if you're aware that the laws are changing, which will impact the bottom line in a way that will impact the bottom line, you should give advice early as to how the business can position itself to maximize the benefits and reduce, the risks to respond to that regulatory change. So sometimes a regulatory change might mean that your contracts will require that to comply with your contracts, you'll have to perform more work. And so that could be a cue to maybe renegotiate those terms or change your offering, and particularly to ensure that any new deals you enter are future-proofed from the point of view of the upcoming regulation. So, and that unlocks a lot of, commercial value, being proactive with responding to changes in legislation. And in terms of contract, it's what we've been talking this whole time, being there early with the commercial team to help them see how the risk could translate into an increase or a decrease in fees, basically. And then also a lawyer's intimate knowledge of licensing arrangements in the SaaS space can give them an insight that other business people might not have into how to monetize certain licensing arrangements. So, for example, your business might be licensing certain elements of its offering for free, but there could be an opportunity to maybe charge fees for, a subset or for all customers, etc. That kind of thing.
Great point, Vladimir. We've done exactly that at Ingenico. So the payment ecosystem is quite complex. You have about 10 to 30 different players to get your money from when you're buying a coffee from your bank to the coffee shop's bank, right? And so we, Ingenico, we're part of that ecosystem, and we have a complex arrangement of licensing that, if not properly advised, you leave a lot of money on the table. And you'll always have this commercial tension around, or this tension between legal and commercial sometimes, where, the legal is stay in your box, don't try and, tell us what to do, or you might have some of that. But I can tell you it does work if you stick at it, and there is an ability to convince your CFO, convince the commercial teams, convince the product teams, and be aligned on this, where everyone gets a favorable outcome. It does work. It's not impossible. So I implore you to take those steps if you can.
Great. So, well, we're heading towards the end of the webcast. So let's, I suppose, wrap up with a few practical takeaways, or some more practical takeaways for our audience. Gihan, in your view, what should the pressure test be for contemporary IT agreements, or what kind of key questions should in-house teams be asking to ensure their contracts are fit for today's tech landscape?
Great question. I would say first thing is understand what the SaaS product is. Whether you're selling it or whether you're procuring it, it's really important from a lawyer's perspective to understand, have deep knowledge on what the product actually does. And from that, that'll unlock a lot of your IT contracting. You'll be able to use either your template that's off the shelf or decide, well, actually, this might not be fit for purpose. Let's just tweak it to encompass these other things that we need and go from there. So that would be, if you take away only one thing, it would be that. Just understand the scope and nature of the product, and that'll unlock a lot when it comes to IT contracting.
I can't agree more with that statement. And I feel like so many problems arise out of people trying to apply contractual language to, boilerplate language to a product that is doing something other than what the language is describing. And it's really challenging because some of the concepts are very nebulous and abstract. Trying to kind of define webhooks and APIs and all of those things and outputs, particularly, to make sure that the specific sort of functionalities of the product you're dealing with are captured. But if you don't understand how it works, you're a lot less likely to properly define the things that are important, and that will lead to risk exposure and issues. So that's definitely a great starting point. And also, I'd recommend watching out for the clauses we've been discussing this whole webinar.
One thing to add on that, I from a practical perspective, what can you do to understand the product? It would be start with your product guide. Sometimes the product teams aren't the best at languaging certain things, so that's okay. Get a diagram. What about a flow chart? What about how does this system interact with my data? How about asking these types of questions will get you a really good fundamental base understanding of, all right, how is this SaaS product different to the SaaS product that I'm getting from Microsoft off my E3 license? Or how is it different to my Claude subscription that's off the shelf? Like these types of questions, the more you dig deep, the more you'll be able to ask these questions, be stronger at SaaS contracting and really sort of deliver a lot of value.
And if you represent a client who is using the product, you need to both understand the product, but also how your client is going to use it. Because, for example, your client might not be using all of the features, which can make many clauses redundant. Or in fact, if your client wants to use it in a different way than you would expect, you need to make sure that you cater for that in the contract. So, that's also a very important exercise. Sometimes, particularly in the private practice, it's a high pressure, fast paced environment. Sometimes lawyers get MSAs or SaaS agreements with very little context about what it is, how a business might use it. And they're asked to, red flag the thing. But how do you know what you're red flagging if you don't understand A, what the product is, and B, how it's going to be used? So it's a very vital exercise to perform, for sure.
Well, thank you both. It's been a pleasure chatting with both of you, and I hope our conversation has given our listeners some very practical tips when it comes to managing IT agreements, and obviously where legal can play a huge role in creating value as well. For me, some of the big takeaways from this discussion have obviously been around, partnering with the businesses early, as well as really getting to know your product as well as the product that you're acquiring, and then obviously kind of making sure that we're future-proofing IT contracts as well in this very uncertain and fast-paced time in terms of change and improvement. So Thank you too to our viewers. I've seen a number of questions come through. So some hopefully we've answered, but obviously we'll review them after this and send a thorough response in our FAQs in the next couple of days. Before we wrap up, a quick reminder that if you do need support to review your IT agreements so that they're structured for both risk management and value capture and value add, Vlad, myself, the whole commercial team here at Law Squared are more than happy to help. So please reach out. We'll pop our contact details in the chat section as well. That's it from us. Thanks and goodbye.